Good evening. Good evening. My name is Mohammed Faridi, and I am the president of this association. For those, I see a lot of new faces here. I see many familiar faces, but some new faces. So for those who don't know us, we are one of the oldest bar associations in the country. I think we recently celebrated our 154th anniversary. 155th anniversary is coming up this year. And I think that in the times that we're living in today, it is important for those who are not members of the bar to join our association and other associations out there, because I think you'll all agree that the rule of law is important. We all need to stand up for it, and our association was founded on the principles of the rule of law, enhancing the rule of law, protecting the rule of law, and we can all use your help in the next several years. Okay. So it is my great pleasure to welcome you all to this year's Leslie Arps Memorial Lecture. This particular lecture series, one of the most distinguished series at our association, serves as a forum for insightful discussions on some of the most pressing and sometimes vexing legal issues of our time. And we are honored to have you all here tonight. I want to extend our deep appreciation for the law firm of Skadden, Arps, Slate, Meagher, and Flom for the firm's generous sponsorship of this lecture over the years. It is particularly fitting that this lecture series is named after Leslie Arps, one of the founding partners of Skadden, who was not only widely respected for his brilliance as a lawyer, but also for his deep commitment to the rule of law and the highest standards of professional excellence. His legacy lives on through this lecture series, which has brought together some of the most distinguished members of the bench and the bar over the years. And this lecture has been previously given by some of the luminaries and the legends of the bar, including Justices Powell, Kagan, and O'Connor, Judges Oakes, Katzmann, Newman, and Gleeson, and Dean Feerick, who's here today, and Leon Silverman, among others. There is one common theme that emerges from the prior lectures, and that's the theme that our legal systems, evolving challenges, and the role of the judiciary in the legal profession is necessary in safeguarding access to justice and enhancing the rule of law. Whether addressing corporate governance, constitutional law issues, or the impact of technological changes, these lectures have consistently provided a forum for thoughtful discussion on the legal principles that shape our society. And tonight's lecture will undoubtedly continue in that tradition. Tonight, we are privileged to hear from Judge Sullivan, whose career has exemplified the qualities of intellect, integrity, and public service that this lecture seeks to highlight. He is widely recognized for his keen legal mind, his thoughtful jurisprudence, and his significant contributions to the administration of justice. We are fortunate to have him this evening to share his insights, and he will be introduced by Scott Musoff from Skadden. Once again, thank you for joining us. Look forward to this engaging and enlightening discussion. Scott, I'll turn it over to you to introduce the judge.
Thank you, Mohammed, and thank you for your communications today on behalf of the City Bar. Just one quick note on Les Arps, and Dean Feerick could certainly speak to this firsthand, but especially to newer members of the bar, he really stood for the importance of getting outside of the office, making this a profession, not a business, and public service. He followed his mentor Harlan to Europe to serve in World War II. Upon returning, went back into private practice and then founded a small firm at the time with Marshall Skadden and John Slate, because they couldn't make partner at some of the white shoe firms. And then continued public service, leading the Moreland Commission and the Waterfront Commission, and as Mohammed said, upholding the highest integrity of the bar. So I think it's an appropriate lecture series that Barry Garfinkel, who espoused those same principles, chaired for so many years and got this lecture series off the ground. So I couldn't think of anybody more appropriate to deliver this lecture than Judge Sullivan. For those that don't know, his career comes from so many different vantage points. Private practice at a preeminent New York firm at Wachtell Lipton, over a decade as an assistant U.S. attorney, recipient of the Stimson Medal, among so many other accolades, leading the International Narcotics Task Force. You don't want to go on vacation with him to Mexico or Central America, I could tell you that for sure. And then back into in-house counsel, up to general counsel at Marsh. So really seeing the things from so many vantage points, and of course now a Second Circuit judge. And I just want to mention two stories, paraphrase two anecdotes that Judge Sullivan, during his confirmation hearings for the Second Circuit, noted, and I just think they're so profound from a perspective, insight into Judge Sullivan, and I won't do them justice the way he did, but one was asked about sort of his progression of thinking as on the bench, and he talked about how when he was an assistant at sentencings, he sat at the front table facing the judge, and he viewed sentencings as very profound and important, but didn't get a chance to really see behind him, heard voices from behind. And his view from the bench, seeing the defendant, seeing the defendant's family, seeing the impact it had, really gave him a different perspective. And I think that was very profound. The other one was a story about how he's handled so many cases under the ADA as a judge, and seeing both sides of that and seeing it go through. But one day during jury selection, I think it's appropriate for the theme of tonight's lecture, he called up a prospective juror, and the juror was in a wheelchair, and he realized that the courtroom wasn't equipped. Despite all the ADA cases that he had before him, he realized that his own courtroom wasn't equipped appropriately. And they rolled the juror next to the box because they couldn't get over fit the wheelchair, of course, in there. And the juror had to sit several inches below the other prospective jurors. And that also left a profound impact on the judge. And I think noting those two stories as part of a confirmation hearing is quite compelling. So without further ado, I'm going to introduce Judge Sullivan. Thank you so much for doing tonight's lecture.
Well, thank you, and thank you for coming out. And I would say the key to these things usually is set the bar low, and so I'm not sure that Scott was effective in that regard. I will say that, you listen to your own biography and you start to get like Springsteen and think about glory days. And, I did fancy myself a trial lawyer, and I thought I was a pretty good trial lawyer, but maybe I really wasn't. But what I did learn as a trial lawyer is don't read to an audience and don't lecture. And so what I learned over time was that PowerPoints are very valuable. And one of the stories that Scott told about the Americans with Disabilities Act, I told that story just this week to a group of middle school students who come to our courthouse. And they are very impressionable, but they got it because it's something I think many of them have lived with, so they're very sensitive to it. But I don't think they realized just what a revolution that was when that statute was passed. But what I've learned with them is also to always use a PowerPoint because you cannot keep their attention if you don't. So I'm using a PowerPoint. I hope that's okay. The nice thing about PowerPoints is, well, there is Leslie Arps. And I think it's worth remembering who he is. Leslie Arps is probably most famous as one of the founders of Skadden, which is probably the most important law firm of the 20th century. If you've read Link Kaplan's book about Skadden, it sort of explains this transformational firm and how it really ushered in a new era of law firm practice and the business of law. But he was first and foremost a litigator. That is what he did. He litigated, and as a litigator, that meant also that he had in his toolbox trial skills. He tried cases. John Feerick could probably tell us about that. But so he did pride himself on being able to try a case. And so I thought in picking a topic, why not pick something that Leslie Arps might himself find interesting, and that he, 40 years later might look back and say, wow, we've really come a long way, and is this inevitable, or is there something we can do about it? The reality is, and the topic that I'm going to talk about is the dearth of jury trials. This is true civilly and in criminal cases. It's true state and federal. This is a phenomenon. I will tell you that, in our system, I think I get visitors to the courthouse a lot, and sometimes foreign tourists, sometimes foreign jurists, sometimes students, and they come in, and if they're from a different country, they look at our courthouse and they're drawn to that jury box. Because most countries don't have the same jury tradition we do, and their courtrooms don't typically have that kind of a setup. And so they look at them and they are fascinated. They also see our TV shows, and so they understand what goes on. But, the jury, the American jury is about as American as apple pie, baseball, and blue jeans. That is an American thing. I know it started in England, but it really is part of our DNA. That is true if you just watch media. I mean, there is always going on some trial of the century. And, I could update this slide monthly and have new cases to talk about. But the point is that our culture pays attention to itself through trials, no question about it. Our entertainment is all about trials. I mean, this, obviously my cousin Vinny is the best trial lawyer ever, a trial movie ever, but there are some other really good ones. And there's something inherently dramatic about trials, of course. It makes for good drama. But it also is a window into our system of justice, into our values as a nation. That's the way we've done it for over 200 plus years, 230 years. But the reality is that those numbers are changing. Now, the numbers are sometimes hard to get, so I will tell you that I've tried to focus on federal court trials because the feds often have easier stats to get, and even those are not perfect. But I will tell you, in 1938, and we'll come back to 1938 in a minute, almost 20% of civil cases were resolved at trial. That's a really high number. By the early 60s, it had been dropped in half. By the turn of the century, we were way down. We were down under 2%. And now that's where we continue to be. Whoops, I don't want to blow through that one. But so a civil trial in a federal courthouse is a rarity. I see some of my colleagues here, and I will ask them, hey, you got any trials coming up? I miss that on the Court of Appeals, so I try to live vicariously through them, and I say, you got any trials? And they will say, yeah, I was supposed to, but it bled out or it settled, and it's quite rare that we're getting trials. Other numbers I'll just sort of throw at you. 1990, we had just shy of 5,000 civil jury trials. 25 years later, it had dropped 60%. I'll keep going in this vein. Criminal cases. 1945, about 20% of cases, between 15 and 20% of criminal cases were resolved by trials. 80% or so, 80 to 85% by plea. That was basically true even in the early 80s. And then it changed precipitously, and we'll talk about why in a minute. But the numbers have steadily dropped to the point where we are now at about 2% of cases or less of federal criminal cases going to trial. It is a rarity for sure. This is a chart I found, and it's a little outdated, so I did the data just about the number of criminal defendants opting to go to trial. It's now about 1,300, and probably even fewer than that, down from 4,700 25 years ago. So something's going on here. That's a 72% drop in a quarter of a century. In addition, jury selected. I mean, jury duty is one of the staples of U.S. citizenship. I just swore in new citizens last week, and they're going to be back to serve as jurors. But the number of juries selected on an annual basis is a fraction of what it was before. And the number of people being called to the courthouse to serve on juries is way, way down. Look at those numbers. It used to be 300,000 less than 20 years ago. And now it's under 200,000. And the number who are actually serving on a jury is less than 40,000 nationwide, federal court cases. So the shared experience of having served on a jury is something that cannot be assumed anymore. I talk to so many people and I'll ask, have you served on a jury ever? And they will say, no, I haven't. And that is becoming a reality. And so why are there so few trials? And I think that's the question worth asking. Well, I go back to 1938. That is the year that we instituted the Federal Rules of Civil Procedure. Those were a long time coming. I have some pictures. This is Homer Cummings. He was the Attorney General at the time. This guy here in a blurry picture is Charles Clark. Charles Clark was a professor at Yale Law School. He was the reporter to the Federal Rules Committee that helped launch these Federal Rules of Civil Procedure. He later became the Dean of Yale Law School. He later became a judge on the Second Circuit and the Chief Judge on the Second Circuit. But he ushered in this new era, which was very different than the old era. And it created basically an impetus to have a just and speedy and inexpensive determination of every action and proceeding in the civil context. And what they had in mind was not that different for about 100 years in our country. Abraham Lincoln was a trial lawyer. He's famous as probably our greatest president. I think I'll go out on a limb and say that. He's famous for other stuff too. I just found this. Yeah, he was apparently a vampire hunter. This is from the best-selling author of Pride and Prejudice and Zombies. This vampire hunter was made into a movie, actually. But Lincoln is really famous as a trial lawyer. And Lincoln would ride into town, ride circuit with the judge and other lawyers, and they would hit the town and they would pick up what was there. And they would try multiple cases a day. In the span of a few days, they would then make arrangements to come back and try the next set when the next time they were through the town on circuit. That's a very different model. But the reality was, it didn't take years to litigate cases. It was quick. It was informal. It was where a lawyer made a difference, and that's where Lincoln cut his teeth as a lawyer. The federal rules changed that and basically ushered in a world where lawyers, for the most part, unsupervised, are running litigation. Depositions are not something that we've had forever. Depositions are now, you take them for granted, but most countries, or many countries, don't have them, and this country didn't always have them. But the reality is that we now have a system where, by and large, the lawyers are going to figure this out through discovery, depositions, and then ultimately motions, and cases will be resolved that way. And I'm not sure that that wasn't the goal. It does seem to me that that ultimately was the goal. We've had changes in the law, so we had summary judgment has turned into a much more common tool starting in the early 80s to resolve cases long before they get to trial. Same thing for pleading standards, Iqbal and Twombly. That's now, everybody knows what that is, but that enables parties to bring motions resolving cases before they even have discovery, in part because of just the expense of discovery. Why else? Arbitration. I mean, we live in a world where at least serious commercial parties are negotiating in advance to have cases resolved outside of court. Part of it may be a fear of juries or a fear of judges, or maybe it's also a fear of the federal rules because they think that they might be able to do this more cheaply in a more informal setting with no depositions or limited depositions, with limited discovery. So I don't know if this is a real number, but it's been estimated that at least in commercial cases, 50 to 60% of disputes are resolved through arbitration by agreements between the parties. That's an interesting development and one that certainly is having an impact on what hits my docket, both when I was on the district court and on the circuit. Court-sponsored mediation, an ADR. John Feerick is here. I mean, virtually every court in America now is in the business of resolving cases this way. That's not a bad thing. I don't necessarily, I'm not condemning it, but the reality is we just celebrated the 50th anniversary of the Court of Appeals mediation program, CAMP. And the data that they shared is that they basically, this is at the Court of Appeals. I mean, the costs are pretty sunk at that point. And yet, of the cases that get referred to the CAMP mediation program, well over a third are settling before the case goes to its appeal. And in the district courts, Southern and Eastern District, like most districts around the country, have their mediation and alternative dispute resolution programs that resolve up to 65% of cases going through those programs. That's never mind, the informal resolutions that happen between the parties. So that is definitely a reality that didn't exist when Lincoln was doing his thing, or even when the federal rules broke out. Another thing that's worth noting is that the numbers have gone up. So Bob Fisk spoke at the 200th anniversary of the Southern District of New York in 1989. And he talked about the docket as it existed then compared to when the court first began. We had then had the 225th anniversary in 2014, and Bob Fisk got invited again. Now, why do you have a 225th? Well, it's because I guess we do it because, you know, we worry we won't make it to the 250th. But one of the points he made, which was interesting, is that the number of judges had stayed basically constant, but the number of case filings had nearly doubled. And so judges were having to do more with less, and were able to do it because of technology, court support, clerks, things like that. But the reality is that that does change the way courts operate. If you are a judge and you've got a gazillion motions that are piled up from the hundreds of cases that you have, it's hard to find a month to try a case. Discovery costs. This is an easy one, low-hanging fruit. This is one, I mean, you could go to a CLE program every week, I think, on discovery costs and how prohibitive the costs are. I actually think we're moving in a direction now where discovery costs might go down because of AI, and there might be a real savings as a result of electronic discovery. But one thing I learned as a general counsel is that electronic discovery is like nuclear waste. You cannot get rid of it. It exists forever, and it just piles up. And that does lead to more expensive litigation. And that's even true on the criminal side of things. Where it used to be, if you were doing drug cases like I was, I mean, whatever the guy had in his pockets, it was what you got. Now everybody is walking around with a supercomputer that has got GPS and communications through text and email and everything else, a phone log, photos. It is, you know, there is gold in those things, but it takes time, and that can become prohibitively expensive. I think, and I mean, I learned this in the insurance industry, we're better at assessing risk. I mean, we had a huge litigation docket, and we were able to figure out what were the risky ones that we had to worry about, what were the ones that we could just take their course, and what ones we could settle now. We were getting good at that, and I think other sophisticated litigants who do this all the time are also getting good at that, and that does explain why cases don't go to trial. And then this one, I think, is one that Les Arps would be able to talk about. The business of law has changed. I think since the 30s and the federal rules, I think sophisticated lawyers came to realize there's a lot more money to be made litigating than trying cases, that discovery and depositions and motions are really, especially if you're on the billable hour, is where you're going to make your dough. Trials, you know, trials are risky, and trials are, it's often hard to be juggling lots of matters when you're on trial. I often tell students of mine, I said, just for fun this summer when you're at a firm, why don't you, when you're at a fancy lunch with the lawyers there, the partners, ask them, who do you think is the best trial lawyer at the firm? And they will look at you like a dog that's heard a funny noise, because I think they don't think of it in those terms, because the reality is they're so rare that trial lawyering skills are icing on the cake maybe, but that's not really what makes you a leading partner at a firm anymore. And so the world has changed on the civil side. Criminal side, I think, you know, the world has changed as well. We still have very, very few trials. Both civil and criminal are going way, way down, and that on the criminal side, a lot of it is attributable to the sentencing guidelines. I mean, when the guidelines became effective in 1987, they immediately ushered in a period of declining trial rates. And part of it was that lawyers and clients could figure out what the costs were of going to trial. It became a much more predictable outcome. And so that is certainly a fact that has impacted what happens with trials. But it's not just that. I would say mandatory minimums that coincided around the same time also contributed to this. Now, mandatory minimums do not have to be a basis for fewer trials. If everybody who had 5 kilos was charged with a mandatory minimum sentence and was going to get 10 regardless, then people might say, well, if I'm going to get 10, whether I go to trial or plead guilty, I might as well go to trial. The difference is that mandatory minimums have been able to be used as a cudgel. This is a cudgel, if you've heard the term. A lot of people know what the word means, but that's what it looks like, and that does convey what a cudgel can do. It can be a very persuasive tool. And that is the reality of federal plea negotiations after the guidelines and after the imposition of mandatory minimums by Congress. It meant that prosecutors had the ability to basically dictate terms. What Jerry Lynch, my colleague, Jerry Lynch once referred to in an article as our administrative system of criminal justice. It's really not as adversarial a system anymore because one side has basically got all the tools. That, I think, is combined with prosecutorial discretion, where prosecutors do have the ability to basically make deals for people who plead early and punish those who don't in ways that, sometimes I think is understandable and other times may be more problematic. I think it is worth considering what we mean by a trial penalty. Trial penalty in some ways means just the fact that under the sentencing guidelines, if you go to trial, you're not going to get a 3-level reduction for accepting responsibility. There's this little bump that you get if you plead early, and it can sometimes be significant depending on how serious the crime is and what your criminal history is. It means that you might actually shave a couple of years off by pleading guilty. But trial penalty also can mean that if you don't take this plea, the prosecution will supersede and add mandatory minimums, add mandatory consecutives that will increase the exposure. I mean, I think many judges would tell you about this. I mean, I had a case where the government offered the guy 10. He was a serious criminal. This was not a joke. I mean, there was pretty bad behavior there, but they offered him 10 under the guidelines. He didn't take it, and then the superseders poured in, and by the time he went to trial, he was looking at 54 minimum. Well, that's a trial penalty for not taking the deal. Maybe he should have taken that deal. He made a motion afterwards saying that he was not competent, because what sort of competent person would turn down 10 and risk 54? But the reality is, I think, the question had to be asked, were 10 and 54 both just outcomes? Was the extra 44 years to deter criminal conduct or to deter going to trial? And is that appropriate? I think that's a fair question to ask. But another trial penalty that is, I think, more difficult to correct for is the trial penalty that comes when you go to trial and the judge who will be sentencing you now learns a lot more about you than would have been the case if you had pled guilty. The Sentencing Commission has shown that judges are much more likely to sentence below a guidelines range on a guilty plea than they are after a trial. That is a trial penalty that is, maybe it's human nature, maybe that is just the nature of trials, is that if the government's going to trial, they're going to prove their case with more witnesses, better evidence, and no one would fault them for that. That's just the way it goes. But it is going to have an impact on the sentencing, and rational defendants will take that into account when they decide whether to go to trial. I do think this is part of it, better law enforcement tools. DNA is now everywhere. The ability to pull things off of phones, GPS, et cetera. It is, the government is going to the grand jury with a lot better proof now than would have been true 30 years ago. That is going to have an impact on trial rates. And then this is, I think, another real driver, fear and inexperience. I think if you are a lawyer who has not tried cases, you are going to find a way not to try cases. And I think that is something that is controllable, and I think that is something that every lawyer ought to be concerned and thinking about. So who cares? Maybe this doesn't matter. I don't know if anybody knows who this is. This is John Langbine. He's a professor at Yale Law School, professor emeritus now. He's a legal historian, and he's done a lot of work on jury trials, the tradition of jury trials, and what drove them and what's the future of them. And his view is basically, it's over, folks. It's basically like harking back to buggies. Times have changed. The Association of Corporate Counsel, I was once a member of that as a general counsel. They had the same view, I think, basically, which was, hey, the world has changed. We now have a professionalized justice system. We are very concerned about costs. This might be ways to streamline costs. We want predictability. We want anonymity in many cases. I think the beauty of arbitration is that you can do a lot of this under the radar, which is very attractive to some litigants. And as we become more global, there are more CEOs of companies who do not know anything about the American system other than what they read in the papers, which is that juries can award big, big punitive damages for hot coffee. And so they are reluctant to get brought into this kind of a world. Maybe it's irrational, maybe they are overthinking it or they're misinformed, but that is certainly a reality. So why do juries matter? I'm going to just sort of blow through a few of these to explain why I think they matter. First of all, it's our heritage. I mean, it's in the Constitution, yeah, but it's more than just in the Constitution. I mean, this goes back to the very beginning of this country. The Jamestown Charter, the first charter of Virginia, calls for jury trials. That's 1606. The Massachusetts colony, the Pilgrims, also the right to a jury trial for criminal and for civil cases that involve money. That's 1620, 1623. Virtually every colony in the Americas had embraced jury trials and that right, even before the Glorious Revolution in England. And so very much the colonists embraced this, even perhaps more than their English forebears. Not always honored it was sometimes honored in the breach, but we had some of the most famous jury trials in history to that point in American trials. The John Peter Zenger trial. Zenger, this was the first defamation case. He basically was a libel case. He reported on the colonial governor removing a judge in a case. He was critical of it. And then he found himself in jail for seditious libel. It was a public trial by a jury, and the jury acquitted him and basically launched the notion that truth is an absolute defense to libel. But that was an American trial that is one of the most famous in the history of mankind. Same thing with the Boston Massacre case. John Adams, who was involved in the Declaration of Independence, second president of the United States, he's got a lot of stuff he's proud of. He looked back at representing British soldiers who were accused of killing civilians and charged with murder. He viewed that as one of the most important public services that he did, representing those soldiers in a public trial and getting them off. So we have a long tradition of this. The Declaration of Independence it's a list of gripes. On the 4th of July, we read the Declaration in my house, my poor children, but that's what we do. And there's a lot of complaints about what the king is doing, and one of them is he's suspending jury trials. Can't have it. Thomas Jefferson considered the jury trial as the most important right of all. And so this is definitely our heritage. Every one of the 13 original states had jury trials, mostly for civil and criminal, in their constitutions. Massachusetts, since 1780, has had criminal and civil jury trials in its constitution. So why else does this matter? Well, I think, frankly, juries are pretty good at finding facts. I think they're very good at assessing credibility. I think they're at least as good as I am, candidly. There are 12 sets of eyes with different experience. And also, the fact is that this is their first time in court for many of them. And so they have fresh eyes. I think don't underestimate that. G.K. Chesterton, who's an Englishman, famous for the Father Brown series, if you've read them. But he was a philosopher and a writer, and he wrote an essay about jury service in 1909, his jury duty service. And what he said was that the movement of history is towards professionalization. And that's particularly true in the legal field. And there are a lot who are saying we should take the role of judging from the jury and give it to professional judges. And Chesterton was skeptical of that. He said, not because judges are bad or wicked or dumb. No, it's just that they get used to it. They just basically see the man in the dock, and they just think, well, that's the way it goes. That's just the person in his usual place. They come to court, and they aren't moved by it. This is just where they work every day. There's something about having citizen jurors come to the courthouse and experience this for the first time, or at least not as a usual thing, that makes them very valuable, I think, in assessing credibility and deciding facts. I think they're pretty good at it, at least in my experience. Why else do they matter? I think juries legitimize the legal process in a way that a judge can't. I do think to have the jury speak and give its imprimatur on this decision, on a case, that counts for something, and it brings some finality and it brings some healing, I think, to communities that have a big, high-profile case. I think the jury doing a verdict makes it different, and I think that's not something that should be lightly dismissed. Juries having trials, but jury trials and bench trials, but having trials does develop the law. I mean, I have to say, so I had this group of American and international general counsel when I was a judge at that point, and I asked them, look, you guys can litigate any place. If you could choose your forum and your law, where would you go and what law would you apply? Almost to a person, they said, I would go to arbitration in London and I would apply New York or UK law. They like New York law. New York law is rich. It has a long history. It's predictable. They view it as very good law. And I said, well, if you keep going to arbitration, though, there won't be any more of this law. We're not going to be able to replenish it. We won't be able to have law that deals with new situations, new technologies, new creative systems of doing business. And, you know, I think they took the point, but they were like, well, short term, we just think this is cheaper and faster. But the reality is, if you don't have a trial in a criminal case, I mean, if you took a plea, you're probably not going to get to challenge what was decided in that case. You won't be able to challenge the statute. You won't be able to do much of anything. Most of what's coming out of the Supreme Court now are cases that went to trial. And then and only then there's an opportunity to challenge a statute or to challenge a ruling. I do think that juries are very good at checking government overreach. They are able to nullify. They don't do it often, but they can. They can look at a case and say, I don't like what's going on here. I lost a case as a trial, and man, I can't believe it because I should have won that case. But I think the jury looked at my cooperator and looked at my defendant and said, I'm not saying he's lying, but I'm saying he's a lot worse than the guy he testified against. And I think they just said, we're not doing it. And that is a function of the jury that they get to do. I think the framers were very worried about despots, star chambers, authoritarian actors who would take the jury away from the people. And they wanted to make sure that that did not happen. And so I'll blow through these. So this is, you know, Patrick Henry and Richard Henry Lee, James Madison, John Dickinson. Some of these were Federalists who supported the Constitution. Some were anti-Federalists. But they were united in the importance of jury trials. Why else do they matter? I think they promote transparency. So you heard I did a lot of cases that touched on other countries, Mexico and Colombia. And those were code systems. They didn't have juries. They didn't do things with live testimony for the most part. Everything was on paper, submitted to a judge. It was much harder for the public to follow proceedings. Unlike here, where everything is really focused on ultimately being decided by a jury, and so it means that there is a transparency in our system that leads it, it makes it much easier, I think, for the press to follow our proceedings and for the public, therefore, to also follow our proceedings. That is a strength. They can sometimes be sensationalist. I would agree with that. But the alternative is elites talking to elites about things that the ordinary press is not going to take the time to follow up on. I think this is a strength of our system where we have juries. I do think also that juries promote democracy. There is no more democratic institution than a jury. Much more democratic than Congress, much more democratic than the federal bench, much more democratic than the history of presidents that we've had. We have, I've heard it described as a bicameral judiciary with life-tenured judges. And life tenure can be a good thing. I mean, it leads to independence. But it is tempered by a citizen jury judiciary, the judges of the facts, who come in temporarily for a short period of time, but who participate in this process. It is a participatory role, the only participatory role that we have as citizens. That does promote democracy, and it is something that I think should not be sneezed at. We have, for a long time, like 100 years, we had juries that looked like this. And we have worked steadily to get juries that look like this, that look more like a community. That has been something we've worked hard at. And so it's ironic in some ways and frustrating in others that we're going to these juries less, even now that they are more reflective than they've ever been. Frederick Douglass recognized the importance of juries. The Fugitive Slave Act did not allow the suspected or the accused fugitive slave to testify, and also an all-white jury was going to make it much harder to win in a case like that if it went to trial. For a long time, we had all-white juries in the South that would never have been able to do what they did had they been integrated juries, no question about it. That is something Douglass and so many civil rights leaders recognized, the need to make sure that our juries were reflective of our communities. Susan B. Anthony voted in 1872. I don't know if you know that, but she voted in the presidential election, and she got prosecuted for it. She violated a federal statute in doing it, and she had a trial. It's a fascinating trial. I teach it in my class at Columbia. But it's fascinating because she also couldn't testify. She wasn't allowed to be heard until she was being sentenced. And the first thing she said when she was about to be sentenced was, I don't recognize the legitimacy of this trial because This was not a jury of my peers. There was not a single woman on this jury. And she had a point. For the next 50 years, that's how long it took to get to vote, rights to vote and rights to serve on a jury were sort of tandem. They basically went together. This is the first woman who ever served on a jury, 1870 in Wyoming. The western states tended to have suffrage and jury service before the eastern states. This is kind of interesting. This is the worst law movie of all time, I would say. Have you ever seen this, 12 Angry Men? I really don't like this movie. I don't like what it shows about the jury. They're doing all sorts of things they shouldn't be doing. They're going out and bringing in evidence. They are doing their own investigation, which I always tell them not to do. But the other thing I found sort of just unrealistic about it was like 12 Angry Men. When are you going to get a 12-man jury? Like, that just seemed unrealistic to me. That's about the only thing realistic about this movie. New York City, women did not get the right to serve on a jury until 1937. This is a famous Norman Rockwell painting. It's kind of funny. I mean, his are often kind of funny, but Rye. And there, if you can see it, it's the jury room, and it's 11 male jurors haranguing a female juror who appears to be a holdout. Kind of funny. It was painted in 1959, which makes it pretty timely because Massachusetts, liberal, blue Massachusetts, did not give women the right to serve on juries until 1950. Mississippi not until 1968. The Federal Civil Rights Act of 1957 is the first federal statute that recognized the right of women to serve and made it clear that they couldn't be treated differently than men in terms of service and where you went to determine who was on the rolls. So this is an interesting history that I think people should focus on and remember that juries are democratic and they are more reflective of our society than any other institution. Why are we not using them? Why are we not taking advantage of that? As I said, last week I swore in new citizens. Every one of them will be back, and they are eager to serve. They view that as not just a responsibility of citizenship, a privilege. I hope they'll get the opportunity to do it instead of just showing up and being told to go home. So why else do they matter? I think they make better citizens. I think there is something about having 12 folks who don't know each other from Adam come together, do public service together, and talk. New York City, everybody rides the subways. You could be on a subway car with people who are very different from you. They could be masters of the universe investment bankers and poor people, and they're all on the same subway, but they're not talking. If they're talking, there's trouble, then you're moving to the next car. But a jury, they have to talk. They have to listen. They have to persuade. They have to deliberate. And I'm always so impressed by this. I mean, I remember picking a jury, and I had one guy, and he was in his 40s, well-dressed, and I said, what do you do for a living? To figure out, whether this is to help the lawyers exercise their peremptories. And he said, I'm retired. I'm like, all right, well, before you retired at 40, what did you do? And he was, an investment banker. Next to him in the box was a woman in her 60s, immigrant from Jamaica, crossing guard at a school. Those two became thick as thieves during this trial. They were always chatting. They were always, just together. And I could see at the end of the trial, they exchanged numbers. That jury came back and had a reunion. I remember that. But this was a group of people who would never otherwise have spoken, and yet they came together to do this important public service. And they walked out of there proud, as most juries do, I think, because they recognize that although it's not easy deciding whether someone's guilty, and it's not easy to decide even who wins in a civil case, it's important. And these 12 strangers were prepared to do that kind of judgment. And it's, I always find it inspiring. And so I think it makes them better citizens. They will listen better. They will engage better. They will be more critical thinkers because of that experience. These are my Norman Rockwell paintings. But I think he gets it. And I think don't sneeze at that either. That matters. De Tocqueville was not a great, he actually didn't think that juries were that great at getting the right result, but he thought they were crucial to forging good citizens. And I'll tell you, we're now a couple of centuries later, and I think he was right about that. I still do. So, why this should matter to you? Assuming you're all lawyers, I definitely think this should matter to you because lawyers who know how to try a case are going to get better results. I mean, the reality is, Ted Wells, Beth Wilkinson, they are trial lawyers. If you're up against them and you've never tried a case, you're going to You're going to feel at a disadvantage. Now, those are the giants of the bar. I get that. But maybe you know this guy. Some of you do. That's Murray Richmond. Murray is a character. Murray grew up in the Bronx. He was a social worker, went to law school at New York Law School at night, got his law degree, passed the bar, hung out a shingle, and took cases, mostly criminal cases. And Murray became a pretty prominent lawyer. Now, Murray is a character. He represented a lot of rappers at various points, but he represented all kinds of criminal defendants. But the first time I met Murray was in court. I was a prosecutor. I had about a 20-person indictment, and the magistrate's court was overrun with people, and everybody was coming up and trying to figure out what's going to go on bail. And Murray comes up to me, and he has a Tasmanian devil was on his tie, because it was, that's the kind of guy Murray was. And he said, I'm Murray Richmond. I'm representing this person. You know what I like to do in my cases? I like to treat them like movies, and I like to cast them. You know who I think would play you in the movie? I think it would be Tom Hanks. And you're probably thinking Danny DeVito would play me in the movie, but I don't think so. I think it would be Joe Pesci. I didn't know what to make of this guy. So Murray is a character, but Murray is no dope. Murray understands people. Murray understands juries. Murray understands adversaries. So fast forward about 5 years later, I'm now supervising a unit of about 25 assistants, and I see Murray. And he says, I have a trial coming up against one of your assistants, one of the people I'm supervising. And I said, yeah, I know. He said, she went to Yale Law School. And I said, yeah, I know. And he said, she also clerked on the Supreme Court. And I said, yeah, I know. And he said, I like trying cases against people who clerked on the Supreme Court. You want to know why? Because they're terrified of losing to a guy like me. He was absolutely right. Murray knew he had this advantage because he'd been there, he'd done it, he knew his way around a courtroom. And if you aren't that lawyer, well, you're going to be at a disadvantage. Not to say you can't overcome it, but it should matter to you that you're not getting opportunities. I think trials promote civility. I think that lawyers are nice to each other in the courtroom, generally. I would say as a trial lawyer, I forged some real close friendships with my adversaries. We were fighting hard for diametrically opposite results. But we had to work together to make sure that this thing went off okay, that we kept the judge happy, that we kept the jury happy, that we made sure that things moved efficiently. That required collaboration. And in the course of that collaboration came respect. And then ultimately affection. That, I think, is one of the nice consequences of being a trial lawyer. I will tell you that I think trial lawyers are among the happiest lawyers I met. Murray is a happy guy. Others are happy too. Morgan Chu, great lawyer. Carrie Cohen, Randall Jackson. I'm just throwing up some pictures. But these are folks who try cases, and I think they have very satisfying practices. So that can be you too, and I think you should want to make sure you develop those skills. So what can be done? Well, I don't know. I'm not sure what can be done. I've got some ideas. I would say, one, I think we have to figure out a way to reduce the trial penalty. I think we have to make sure that, although the government obviously has an incentive to get people to plead early, and people who plead early should get a benefit, but it shouldn't be that if you don't take that benefit, you're going to get a 400% penalty. That does seem like that may not be the right thing. That may not be justice. I think that requires limiting or at least curtailing to some extent prosecutorial discretion. I have great respect for prosecutors. I was one. I'm very proud of the service that I did in that job, and I was very impressed with my colleagues. But I think prosecutors have to think about what they're doing in plea negotiations, and they have to decide what is a principled offer. And it can't be, it's 10 today, it'll be 50 tomorrow. I think that is problematic. And not just because it makes trials go away. I think it's problematic on other levels as well. And so that's a conversation I think that we have to have. I think speedy trial actually, I'm always amazed how much time it takes in a federal court case, a criminal case, where there's a speedy trial clock that's supposed to be 70 days, how long those trials take. I think it'd be in everybody's interest. I think it might be in defendants' interest to move these things faster. Others might have a different view on that, but I know that the hardest case I had was one where the defense lawyer said, we're going to go in 70 days. We're not going to wait. And he knew that we would have to sprint to catch up because we thought we were going to have 6 months to a year. I think that that's worth thinking about. Civil cases, I think there's some other things that can be done as well. I think we want to get judges out of the compelled settlement business. I'm not opposed to settlement. I think that we're not talking about, moving to 50%. I'm just saying to go from, less than 1% to maybe, 3%, 4%, 5%. I think that would be salutary for the profession and for justice. I used to, when I was teaching at Fordham, I taught a summer program where my students were interning for judges. And one of them said to me, oh, it's great. The judge really doesn't have any cases that go to trial because he brings the parties in and he tells them nobody's leaving until we've settled this case. And I just thought, well, I don't know that that's, I mean, the parties might say, okay, we had no choice, but I'm not sure that that is the goal, to say nobody gets to go to trial. I will make you wish you hadn't tried. So I think we have to watch that. Discovery, I think we have to worry about discovery costs. I mean, I think a lot of people are choosing arbitration because they are concerned about the costs here, especially if they're international companies that are not comfortable with our system with heavy depositions and heavy document production. I do think we have to consider whether there are things we can do legislatively through rules changes that will make our system faster, cheaper, and just smarter. That's more conducive to meeting the needs of litigants. I think that's not always easy because different litigants have different perspectives and different goals, but I think we have to think about that at least. I would say as a former general counsel, I would say it's appropriate to, you're a lawyer, talk to the general counsel about what you're putting in contracts about arbitration provisions. Because I think there are a lot of general counsel who would say, I'd like a right to appeal. But that's a downside to arbitration. That I thought I had a really strong case. I think that the arbitrator really botched it, and there's virtually no way that's going to get reviewed. I'd like a right to appeal. And I think that you could probably negotiate situations where if you really are afraid of juries, you could have a bench trial. If you really wanted to limit discovery costs, you could say, okay, no motions or limited motions, limited discovery, no depositions or just 5 depositions. There are things that could be done among sophisticated parties who are negotiating in advance in the event that they have a dispute. And I think that that could make a difference. And this is one I think that would make a difference. I think if you had more judges, I think judges would be freer to try cases. I can't tell you how many of my colleagues will say, I had a trial coming up next week. I was really pumped about it. I was looking forward to it, but I'm kind of relieved that it's settled because I don't know where I would have found the time to do all the other stuff. I think maybe we need to figure out if we have to have more judges and sort of figure out what is the optimal number of cases for a judge to have, recognizing that trials have to be part of the equation. And what can we do to encourage trial attorneys? So I'll wrap this up pretty soon, but I think we have to teach trial skills in law school. John Feerick is here, former dean of Fordham Law School. Fordham has a great trial ad program. I taught in that program for a while, but what was great about it is I had 12 students, but I also had 4 professional actors, including this guy. This is Tibor Feldman. Maybe you don't recognize Tibor, but if you watch TV, you will see Tibor. He was in The Devil Wears Prada. He played Meryl Streep's boss, the publisher. He has been in Law and Order. He's been in Sopranos. He's all the time. I see him on TV. But he did this program for a couple of decades. And his view was, I'm an actor. This is great. Keeps my acting skills sharp. And it also helps law students figure out how to learn their craft. And so he would come in character to meet with the students to prep for a direct. And he would come in character to court on the night where we had class to do the direct or cross. Sometimes he'd screw up on purpose, knowing that witnesses sometimes screw up. But that was about as close as you could get to the real thing. He was 40 years older than the students, most of them. And so he could believably play a Vietnam vet in a particular scenario. It was great. I don't know any other law school that does that, but I think that was really a terrific way to teach trial ad. There are a lot of other great ways to learn trial advocacy skills. NITA is really good. American College of Trial Lawyers has programs. There are great books on this that you should read if you want to be a trial lawyer. The City Bar has a lot of great programs that you can take advantage of. I urge you to do it because you want to develop those skills, and you're going to have to develop them in many cases on your own. You can't wait for the firm to do it for you. The practice of law has changed. But that is something that I think you will be a better lawyer, and the profession will be better because you've had that experience. So this is the state courthouse right next door to mine. And it's got a quote over the entrance, and everybody kind of knows it, I think, at this point. What's the quote? Anybody? Somebody knows. Yeah. That is great. I'd give you $1 if I had one. And who said it? Yes, George Washington. To whom? Oh, that's a tough one. To this guy, Edmund Randolph, first Attorney General of the United States, fellow Virginian, and Washington was trying to persuade Randolph to take the job, and he was saying, look, we need you because one of the things we're going to have to do is pick judges. This new Constitution has a third branch, unlike the Articles of Confederation, and we're going to need to pick judges who are up to the task. We're going to need, this was Washington's point, most citizens will never meet the president. Most citizens will never meet their congressional representatives or senators, but they just might end up in court. And their assessment of this entire experiment will turn on that experience. So we need judges, men and only men at that time, and only a certain kind of man, really, but who are people of integrity, energy, who were smart and impartial, who would do justice. And so he thought that was pretty important. I'm not sure he's wrong about that. I still think he's right about that. I think Washington would be very, very proud of the men and women who make up the bench today. Here you are, Loretta. You'd be surprised how long it takes to do this. I do think judges make a difference. I think that Washington was right. That the true administration of justice does turn on judges, but I don't think it's exclusively judges. I think it does turn on jurors, citizens who come to court and play the role of judge of the facts. I think they are part of the true administration of justice as well, and I don't think we should ever forget that. And then, of course, another key player in the true administration of justice is lawyers. That's you folks. Don't ever forget that. The city bar, you come into this building and you feel part of a tradition, this great historic building, and you feel like I'm part of something bigger than me that's going to be here longer than me. But every one of you who is a lawyer took an oath to support and defend the Constitution of the United States. So that's the tradition that you're a part of. That's the tradition that this city bar taps into. I'm sucking up to the people who invited me. So I would say relish that. Recognize that that is one of the privileges of being part of a profession. And recognize that the responsibility is to leave the profession and to leave the institutions of justice stronger than the way you found them. Right now, I think they're strong. I will tell you, I traveled to Colombia and Mexico and places where I was very proud of our institutions, which were not corruptible and could not be intimidated. But I do think that there are things we could do to make it stronger, to make it closer to the people, to make it more responsive to litigants, to make it a better system of justice. And so I think that's something we should think about. Hopefully this is something that gets you just thinking about ideas. This was a lecture. It wasn't meant to be a lecture, more a conversation, or at least some thoughts on a subject that's pretty important and hopefully will continue well past today. So with that, let me say thank you for coming out. I know you got other things to do. And thank you for the award. I'll take questions, sure. Most of people want to get the heck out of here, probably. But questions, yeah. You don't have to. Well, I mean, I don't disagree with what you said.
I'm just going to repeat the question.
Oh, sure.
Essentially, the question was, is it too expensive to get to jury trials in light of what attorneys charge?
In big commercial cases, right. I think that there's some truth to that. I mean, contingent fees should take care of at least some cases, at least on one side of the V. But I think you're right. And I mean, what I observed as a general counsel was lawyers making that kind of money were very reluctant to get up there on stage. I mean, early in the case, they'd say, "Look, this is a winnable case. I think we have a good shot. We can win this case." And then as you're getting closer to a trial date, they're like, "Well, we could lose this case." And when you think about it, $500 million is not that much. With taxes and everything else, that's a win. So I do think there's something to be said about that as well. Well, I think we've got to make sure that justice is affordable, and I think that's what is driving a lot of people to arbitration. It's perceived to be cheaper. Yeah. I think that's a common concern I've heard, and I think, you know, if the parties wanted to negotiate that in advance as part of a contract, they could, and sometimes they do. I have seen that. I have seen that where liability is going to be the jury, judge is going to be damages because damages gets complicated. But I think that, you know, that is going to be a small set of cases where the parties will agree on that. Other times they want to just go for broke. Look, I think punitive is also something that is a almost uniquely American thing. One could ask whether it serves that much purpose. I mean, it's designed to deter a bad actor, but it mostly just provides a windfall for a plaintiff. And there might be better ways to deter and to, you know, I think avoid that kind of uncertainty, because that does make some people just lose all taste for an American trial. Mohammed, and then we'll go back. Well, I don't have to like it or not like it. I mean, I think, you know, generally, there's no question about it. The jury has the authority to do that. One of the issues that comes up once in a while is whether they should be instructed on their right to do that. The law of the Second Circuit is pretty clear. You don't instruct them on that, so they have to know it organically. I think there were a couple of cases that came out of the circuit where judges, in criminal cases, wanted to notify the jury as to what the mandatory minimum penalty was, on the theory that if the jury knew that, they might well nullify or they might take a different view. And there was sort of an originalist spin on that, which was, you know, in 1789, most jurors would have understood probably what the penalties were for a particular crime. And so that would have been baked into their assessment of liability and the potential for nullification. It didn't get any traction in the court. I think generally, though, we want to keep the jury focused on fact-finding. I think they're good at that. I think things that will distract them generally worries me. So I think it can serve a good purpose, and I think the fact that if it's a criminal case, the prosecutor has to think about maybe they would do that. That keeps everybody honest. So I wouldn't want to get rid of it altogether. And it does happen. We just don't really know it because they don't tell us. They don't put it on the verdict form. Yeah. Yeah, that's a great question. So the question was, how do you feel about high-low agreement? Sort of like a baseball arbitration kind of thing, you mean? Yeah, so
We're unaware that no matter where the jury comes in, or a bench trial, or an never pay more than X guaranteed. Let's take it as baseball.
Look, I think these are all things that can eliminate some of the uncertainty that comes with trials, which is a turnoff for some litigants. And I think that all those things are on the table. My worry is that everybody is basically just saying, "Oh, we're going to arbitration, all the way on arbitration." And there are times when arbitration is great. I mean, I do think, as a general counsel of a company, there are times when I liked it because it meant the dirty laundry wasn't coming out. But other times where I think you're giving up a lot by going to arbitration. I think we want to encourage people to think carefully about it. Yeah, look, so I think there's a lot of room for creativity. And I got to say, I think that if a lawyer said to a general counsel, look, you know, we could have a trial, we could agree that we're not going to have more than a couple of depositions, no motion practice, and a high-low arrangement, and we can do this in 3 months or 4 months, I think a lot of folks would say, sign me up for that. So I think that's something that we need to be exploring. Yeah. Look, I think that's true. I think litigants would be open to this. I'm not sure lawyers are always open to this. I mean, I think sometimes the lawyers are the ones who are standing in the way of, trying more creative and streamlined approaches to litigation. So I'm hopeful that sophisticated general counsel will maybe start to think about this, push back a little bit, and urge their outside counsel to think in terms of how we might do this so that we get the benefits of a trial without some of the risks that come with the trial. Yeah. Oh, I'm sorry. Here, and then we can go there. Yeah. So I'm not here to say that. I mean, I don't know enough about it. I'm sort of steeped in my own system and not in others. But I don't think that we should try to make our system more like France. I just think that this is our system. I think that it's worked pretty well, and I think that it doesn't have to be sort of just tossed. So I don't want to criticize anybody else's system. I meet them now with enough judges from other countries, and I realize in talking to them that their system has coherence, it makes sense, and it works for them perhaps. But I think that there are downsides to not having juries. I think that and those things come out in a democracy where we have a participatory system. So I like our system. Maybe I'm just kidding myself. Yeah. I mean, I know of a judge or two that has done that. I think it's a hard thing for a judge to say before knowing the evidence and before knowing facts, to say what, to set a ceiling on a sentencing. I mean, every judge I know takes sentencing very, very seriously. It's a very fact-intensive inquiry in the federal system, and that is a hard thing to do before a trial or in the early stages. When I first came on the bench, I remember a judge saying to me, just be prepared. In your criminal cases, basically all you do are three things. You exclude time under the Speedy Trial Act, you take guilty pleas, and you sentence people. Every once in a while, you'll get a trial. Every once in a while, you'll get a suppression motion. But for the most part, that's really what you're doing. And even at a guilty plea, I have no illusions that I'm in possession of deep facts. So I think it would be hard to come up with a system where judges are going to be in sufficient possession of facts that they could make a representation as to what the sentence will be after a trial. I think most judges will be reluctant to do that. Prosecutors are going to be in a better position to do that, and I think they probably have an obligation to do sort of a high-low. I just think 50 years is a long time. That's just what I said to a group of prosecutors. I said, look, I'm not saying you did anything wrong, because you don't even know if you're going to win on all these counts. But you got to ask yourself, if it's a 54-year mandatory minimum, and you're offered 10, is this a sentence you're going to be proud of in 10 years when you've left, when you're now at Skadden or someplace? And I think that they were thoughtful about it, and they eventually withdrew one of their counts, which carried a 27 mandatory consecutive. So I think that they were willing to consider it, to their credit. But I think it's hard to predict sentencing in advance, would be my short answer. Question over here. Yeah. Well, look, I mean, I think first and foremost, I think lawyers have a real responsibility. I mean, often the bar are the mouthpiece for the bench. I mean, we can't basically get up there and cheerlead most of the time, and we can't respond generally to criticism, right? We can write opinions, but so we need the bar, I think, to step up and articulate, what's a fair criticism, what's an unfair criticism. I think, generally speaking, people are going to, will be unhappy about outcomes. And I think that's fair. I don't think we're saying that nobody gets to criticize our system. And there might be a lot of people in this room who think I'm nuts when I'm sort of romanticizing the jury. But I do think that the organized bar has a special responsibility in that regard, and we look to them to do it. I'm the chair of the Judicial Conference, the U.S. Judicial Conference's Committee on Judicial Security. So I know the kind of threats that are getting made to judges, and in some cases are being carried out against judges or their family members. This is really serious and not hypothetical. So I think every public official has an obligation to speak carefully and thoughtfully about our system of justice and what they should be mindful of the consequences of loose language, I guess, is I think something that everybody should be focused on.
Thank you again, Judge. It was great. And
thank you.
please join us for a reception.